Your Honor, John Dackmeck appearing on behalf of Mr. Smith, who is also here in this virtual hearing.
All right, today's date and time set for preach. What are we doing today?
Your Honor, we were hopeful that there may be some plea agreement between the people and defendant Smith. There is not. So it is the court's pleasure, though I do have a couple inquiries of the court and a request that the court inquire as to verification that former prosecutor Smith is turning himself in to the Federal Bureau of Prisons tomorrow, June 30. If so, I think there is some requests that the people have of the court and the defendant.
All right, counsel, client turning himself in tomorrow. It's a yes or a no.
Yes, he is, Your Honor.
Okay.
In that regard, Your Honor, we would request that the court order that defendant through counsel provide written notification to both the court and the people of the facility or other location that Eric Smith is going to be incarcerated in the Bureau of Prisons. Additionally, if at any time he is scheduled to be released, 30 days prior to that, he notify the court and the people of that tentative release date. So all locations that he is going to be at under BOP and a 30-day notification of the termination of that sentence so that this court may properly adjudicate the matter.
Your Honor, I have no issue with keeping Your Honor apprised and the prosecution apprised of the whereabouts of Mr. Smith. We have been keeping that quiet for some time, I think for obvious reasons. His location is probably not of substance to the public at large, and there is a concern that his known whereabouts to the public at large could be a safety issue for himself. But if Your Honor is so inclined, I'm happy to present that information to the court and the prosecution. I would ask, and perhaps this is something for discussion with Mr. Frezza and I off the record, but since this is the first I've heard of this request, that it be subject to a protective order, that the government not release it in any statement to the public at large, because there is sincerely a concern for his safety.
Well, I guess something you can bring up somewhere else, because I don't understand why. Are you saying that the whereabouts of a federal prisoner, just like a state prisoner, is not part of public knowledge? That's the first I've heard of that.
It is, Your Honor. The public could probably, if someone was so inclined to look into it, I just don't feel, and I'd ask Your Honor's indulgence in not requiring Mr. Smith to be the one to state on the record somewhere where he is serving his sentence.
I think Mr. Frezza specifically said that you would be telling where Mr. Smith would be housed. Second of all, I'm a little, I am not allowed to writ Mr. Smith from wherever he's being housed for trial in this matter until his sentence is completed, his federal sentence is completed.
I don't know if that's the case, Your Honor. I believe
I don't want it to be the case because frankly, that means that, I was told from the beginning of this case that there's going to be 90 days to surrender, but you're working on a resolution. I could have just tried this case in the 3 months that you're all working back and forth. So I don't know if this was always the plan, that to delay this to the point of not trying it and now delaying it again while he actually serves a sentence. So I'm supposed to wait. I don't know how long his sentence is I didn't make a note of it, frankly.
Certainly not from the people, Your Honor. It's a 21-month BOP.
So I don't think I have an obligation for Mr. Smith to wait for his sentence to be served. I don't, and we have an obligation in this state to try cases timely. So, Mr. Deckman, unless you can tell me that there's some law that says I can't sign a writ to have Mr. Smith brought here for trial during his federal sentence, I don't understand. What I just thought I heard is that we can't have a trial in this matter for another 2 years.
No, Your Honor, that wasn't my statement. My only concern was the government's request for the disclosure of the location. I just wanted it to be somewhat
We'll
protected.
need disclosure at some point in
I
order for
understand.
him to rid him out, and that's
Yes.
going to be a public document. You
I
don't
know.
want to disclose it right now. That doesn't matter to me. Don't disclose it right now. But at some point, it's going to be disclosed because I have to sign a writ in order to bring him back to try him.
I understand you. I was just raising an issue that had been brought to my attention while we're conducting this here for the first time.
Okay.
With
So-
that, go ahead. I'm sorry, Your Honor.
No, go ahead.
With that, I don't believe that negotiations have come to a standstill. I think something possibly could be worked out. At this point, I have nothing to present to court as far as a plea agreement. But if Your Honor is inclined to start scheduling the case out, we're prepared for that at this point.
I will send out a scheduling order with the final pretrial and the trial date. It's not that complicated a case that there's going to, well, if it is, but in terms of dates, you're going to get simply a final pretrial date and a trial date. And the trial, it's my understanding, will be conducted in Macomb County live with Macomb County citizens, as those are his peers.
Yes, Your Honor.
But beyond that, I'll just send you out dates, and then two of you will have to work out how much time will be needed back for a writ for Mr. Smith's appearance in court.
Understood, Your Honor.
Okay, so I'll send that out sometime later this week.
Thank you, Your Honor.
Thank
Thank
you,
you.
Your Honor. And in keeping with Mr. Dakmak's statement that there's ongoing negotiations, often courts ask the prosecution to put on the record the sentencing guidelines if convicted as charged. With the court's indulgence, I'll let the court, counsel, and the defendant know that the people, if convicted as charged, including racketeering, the sentencing guidelines will be 57 to 95 months. As Your Honor knows, it is a 20-year felony. I do have another question after that.
We're aware of the guidelines, Your Honor.
Okay, yes.
The other question is if, in the course of plea negotiations, the amount of restitution in an order becomes an issue. I inquire whether the court would be willing to, on a guilty plea, hold a restitution hearing concerning the amount of money that should be in that restitution order under the Crime Victims' Rights Act.
That's
And
I typically, when there's a disagreement as to the amount of restitution, when there's been a guilty plea, I typically will hold a hearing. I have no issue with that.
thank you, Your Honor.
Anything else?
Not from the people, Your Honor.
No, thank you, Your Honor.
If you, I'll also put in deadlines for plea offers and plea acceptances, because I will not sit and bring members of the public in to have a jury case only to say on the day of trial that they will then accept the plea, because that's a waste of everyone's time and money.
Thank
So
you, Your
there'll
Honor.
also be a deadline for the acceptance of any plea offer. All right.
And in that regard, Your Honor, I wanted to alert the court that there will be motions from the people, including motions in limine concerning MRE 404B evidence to present at trial.
All right. I'll put a motion limiting deadline in also.
Thank you, Your Honor.
Anything else?
No, Your
No.
Honor.
Okay, great. Thank you very much. You'll get an order sometime this week. Thank
Thank
you.
you, Your Honor.